This is that hearing, that 10 marks hearing, which was continuing.
Your Lordship, we have to make our submission. Learned Advocate General is on his way. He's coming.
Why don't you start?
Your Lordship, I will just give a brief background on what points will make our submission.
All
Then
right.
Learned Advocate General. He's here. Your Lordship, oh, he's here.
Say. Even say for 2 minutes.
And to start. Yes.
I'm saying court is
Wait, I will take it.
Sorry, my lord.
No, it's all right. But these are opportunities for the juniors
Yes.
to grab.
Yes,
And
definitely.
wait till the senior comes.
But in fact, these opportunities are getting rare. It's
The
not that-
seniors are jobless, you say?
No.
Then
I'm saying from the court's perspective, not every court is kind enough to give that opportunity.
that is different.
But that difference is
I don't comment
no,
on this.
Lordship need not.
Uh.
Neither I am commenting. Lordship need not. I don't want. But I'm saying these opportunities are actually, which we have heard stories about it from our seniors, and we also say that is getting very scarce.
No, my lord, your lordship has been pleased to, my lord, hear several learned counsels in the matter.
Hmm.
So on facts, I don't think, my lord, I need to, my lord, dilate any further.
Hmm.
But I'll try to be as concise as possible. But my first submission would be in the form of exclusion. Exclusion in the sense, number one, my lord, no argument has been advanced before my lord that prior teaching experience is not required. Considering the nature of the job, considering the post prior teaching experience is uncalled for, no submission has been made to this effect. The corollary is prior teaching experience can be one of the qualification.
Yes. Hmm.
Number two is no argument has been made that owing to the prescription of prior teaching experience, the inexperienced, if I may, dissect them into two classes,
Hmm.
the inexperience will be completely eliminated. No argument has been made. The argument is that if you provide for prior teaching experience, then the selection would be one-sided. Milord, I remember, subject to correction by your lordship, Milord, because I was always not present before my lord. Mr. Bikash Ranjan Bhattacharya submitted that except this prior teaching experience, other things are level playing field. Therefore, my second point of elimination is that no argument made that the inexperienced candidates would be completely eliminated. The argument is that it would be one-sided in favor of the experienced one. But these are the two fundamental exclusion that I intend to make. The third, which is a somewhat in the nature of an exclusion, is that why challenge the 2025 rules? Because a line of argument at the beginning was there that Supreme Court meant that 2016 or the fresh selection should be as per the 2016 rules. To that, my lord, this is again in the form of an exclusion also, that take, or assuming for argument's sake on hypothetical basis, if I assume that the 2025 rules is declared to be invalid by this court, but we cannot go back to 2016 rules because there was a 2019 rules in between. Or in other words, the principle which has been laid down by your lordships are that if a rule is declared invalid, that would not revive the superseded rule. Because the superseded rule or the repeal or the rule which has been repealed or the law which has been repealed, on its repeal, it has gone out of the statute book, it has gone out of the rule book as if it never existed. So, my lord, blood cannot be infused to a rule which has ceased to exist by dint of a legislative action. Therefore, we cannot go back to the 2016 rules.
Yes.
Therefore, my lord, what we are left with fundamentally are on two aspects. Number one is, my lord, whether, my lord, weightage can be granted in a selection process. Weightage can be in various forms. Weightage can be, say, age form, weightage can be in marks form, weightage can be in experience form. So fundamentally, the first question which I need to address, your lordship, is whether weightage can be given, my lord, in a selection process, number one. And number two is whether, my lord, the selector can choose between the experienced and the inexperienced. But these are, my lord, the two fundamental arguments which, my lord, I will be advancing before my lord, in support of the rule which has been framed, my lord, in exercise of powers, my lord, under the or the subordinate legislation which has been framed. Now, my lord, first, my lord, I would like to, my lord, confine the mode of challenge to subordinate legislation. Where your lordships have held that the subordinate legislations do not enjoy the same immunity as that of the parent legislation, or in the sense that the presumption of validity at the very beginning, as is applicable in case of a challenge to a parent statute, is not applicable in its full vigor when a subordinate legislation is challenged in court. Therefore, my lord, the Supreme Court has culled out 4 or 5 grounds on which, my lord, the subordinate legislation can be challenged. Those are, first is legislative incompetence, but no one, in my very respectful submission, has said that there is a legislative incompetence. The second is fundamental right violation, which I'll address, Your Lordship. The third is infraction of any other provisions of the Constitution or other constitutional rights. Second and third may require, my lord, Your Lordship's attention. The fourth is not conforming to the authority granted by the primary legislation. Not conforming to the authority granted by the primary legislation. I don't think, my lord, Your Lordship has been addressed on that also. The fifth is repugnant to the parent statute. I don't think that has also been addressed, Your Lordship. The sixth is, which is somewhat ticklish, is arbitrariness. Now, why I use the expression ticklish? Because arbitrariness is not as wide in the context of a subordinate legislation challenge as that of ordinary arbitrariness in other fields. Arbitrariness has been confined to the extent that you have to look into the arbitrariness from the angle that the primary legislation did not confer power to provide for such a provision. That is arbitrariness in the context of challenge to a subordinate legislation. No, it is not that this is arbitrary because you are comparing between black and white. You have to say that the legislation did not confer any power on you to provide for a comparison between black and white. So this arbitrariness, or the sixth Millard facet, is not as wide as the arbitrariness that we understand. Say, for example, Millard, in the commercial field, tenders and all that. So, Millard, these are, Millard, the four. I'm sorry, the 6 fundamental grounds, Millard, on which, Millard, subordinate legislations are challenged. Millard, I think, Millard, I have to address your lordships on the second, third, and sixth aspect. First is, Millard, your lordship, I will not, Millard, multiply decisions on each topic. I'll be as misered as possible. First is, yeah. না ৬-৪ আছে পি কৃষ্ণমূর্তি আগের দিন লাস্ট যেটা বলেছিলাম আচ্ছা 79(3) দে তাহলে Millard, only one request, Millard. I'll be very unfair to the court. But I've got a matter fixed at 2 p.m. It's a continuing matter.
First half.
First half.
अरे है तो 3 नंबर कॉन्फ्रेंस है
এটা কোনটা 79 তো But the first judgment, Millard, in the sequence is 2006 4টা বের করে রাখ is reported in 1979 volume 3 Supreme Court cases 229. But here, Millard, a regulation, Millard, under the Electricity Act was under challenge. One paragraph from this judgment, which is paragraph 41. The grounds of challenging the validity of subordinate legislation are well known. The challenge may be on the ground that the power to make the law could not have been exercised in the circumstances which were prevailing at the time when it was made, or that a condition precedent to the making of the legislation did not exist, or that the authority which made the order was not competent to do so, or that the order was not made according to the procedure prescribed by law, or that its provisions were outside the scope of the enabling power in the parent act, or were otherwise violative of its provisions or of any other existing statute. As it happens, none of these grounds are so and so. Therefore, Millard, in 1979, Millard, the Supreme Court was more concerned about the or confining the challenge to a subordinate legislation more on comparison with the parent legislation. And the situational needs. Now, in 2006, Millard, Supreme Court expands the scope of challenge. Please have a look to Millard, this judgment, which is P. Krishnamurthy, which is consistently followed. This P. Krishnamurthy reported in 2006, volume 4, Supreme Court cases 517. Please come to Millard, paragraph 15, 1-5. There is a presumption in favor of constitutionality or validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds. 1. A. Lack of legislative competence to make the subordinate legislation. B. Violation of fundamental rights guaranteed under the Constitution of India. C. Violation of any provisions of the Constitution of India. D. Failure to conform to the statute under which it is made or exceeding the limits of the authority conferred by the Enabling Act. E. Repugnancy to the laws of the land that is in any enactment. And F. Manifest arbitrariness, unreasonableness to the extent where the court might well say that the legislature never intended to give authority to make such rules. Now, this arbitrariness or unreasonableness is confined to only this part, because arguments are often made that this is arbitrary, this is arbitrary, this is arbitrary. Article 14 is Millard brought in. But in a challenge to a subordinate legislation, Millard, the expressions arbitrariness or unreasonableness does not have its full play. It is connected to what the legislature intended. If the legislature did not intend to provide for prior teaching experience, then of course, Millard, it can. But Millard, we often have seen, Millard, that prior teaching experience or any other weightage has succeeded in court, Millard. There are innumerable judgments, few of which, Millard, I'll place before my Lord. Then, Millard, this P. Krishnamurthy is consistently followed, but I'll show one judgment, two judgments more only, which is 2000. Next one is 2016, volume 7, Supreme Court cases 703. Please note down the paragraph number only. It again quotes P. Krishnamurthy. Para 34. Nothing much on this. Now, the last judgment in this series is 2022 SCC Online SC 444 Dental Council.
এই সাইটেশনটা দিয়ে দাও।
Acha, which is also the regular citation is 2022 volume 6 SCC 65. দিয়ে দে। Please take me at paragraphs 24 onwards. Here, Millard, the subordinate legislation was quashed. The division bench of the High Court V-Day judgment has allowed the writ petition and quashed the impugned notification on 3 grounds. 24.1, that it is violative of Article 19(1)(g), 24.2, that is beyond the scope of the powers of the Council to make delegated legislation as provided under the section. 24.3, that it is violative of Article 14, inasmuch as the dental colleges established prior to the impugned notification would be permitted to run without attachment with medical colleges, whereas the dental colleges established after the impugned notification will be compelled to have such an attachment with the medical colleges. We find that the learned judges of the division bench have erred on all counts. It will be relevant to refer to the following observations of the court in Indian Express. A piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by the statute passed by a competent legislature. Subordinate legislation may be questioned on any of the grounds on which plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the statute under which it is made. It may further be questioned on the ground that it is contrary to some other statute. That is because the subordinate legislation must yield to the plenary legislation. এই আমার কি হচ্ছে বলতো, আমার রোজই পাওয়ার চলে যাচ্ছে,
এখন কি হচ্ছে?
পাওয়ার চলে যাচ্ছে 10% হয়ে গেছে। এটা আনাতে plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the, I'm sorry, Millard, I've missed 1 or 2 lines. It may further be questioned on the ground that it is contrary to some other statute, though it may also be questioned on the ground of unreasonableness. Such unreasonableness should not be in the sense of not being reasonable, but should be in the sense that it is manifestly arbitrary. This is the qualified application. It has further been held by this court in the said case that for challenging the subordinate legislation on the ground of arbitrariness, it can only be done when it is found that it is not in conformity with the statute or that it offends Article 14 of the Constitution. It has further been held that it cannot be done merely on the ground that it is not reasonable or that it has not taken into account relevant circumstances which the court considers relevant. Then, Millard, on the experts field, please take Millard. Then Millard, this Krishnamurti is again considered at para 30. Now, please come to Millard paragraph 41 onwards, where Millard the requirement of the authority is looked into. This court, in unequivocal terms, has held that it would be wholly wrong for the court to substitute its own opinion for that of the legislature or its delegate as to what principle or policy would best serve the objects and purposes of the act. It has been held that it is not permissible for the court to sit in judgment over the wisdom and effectiveness or otherwise of the policy laid down by the regulation making body and declare the regulation to be ultra vires merely on the ground that in the view of the court the impugned provisions will not help to serve the object and purpose of the act. We find that the observations quoted herein above of the division bench of the High Court are totally contrary to the view expressed by this court in so and so. The division bench of the High Court has erred in substituting its wisdom with that of the rule-making body, which is an expert body. In this respect, it will be apposite to refer to the observations of this court in so and so. After considering various judgments on the issue, the court observed, the courts are neither equipped nor have the academic or technical background to substitute themselves in place of statutory, professional, technical bodies and take decisions in academic matters involving standards and quality of technical education. If the courts starts entertaining petitions from individual institutions or students to permit courses of their choice, either for their convenience or to alleviate hardship or to provide better opportunities, or because they think that one course is equal to another without realizing the repercussions on the field of technical education in general, it will lead to chaos in education and deterioration in the standards of education. The role of statutory expert bodies on education and role of courts are well defined by a simple rule. If it is a question of educational policy or an issue involving academic matter, the courts keep their hands off. We are therefore of the considered view that it was not permissible for the division bench of the High Court to enter into an area of experts and hold that the unamended provisions ought to have been preferred over the amended provisions. But somewhat similar submissions are being made. That 2016 rule did not permit or did not provide for prior teaching experience. Then the last paragraph is paragraph 47. I can skip over 47, not that important. Therefore, it's ultimately the requirement of the competent authority or the expert body that has to be given credence. But there can always be a better formula. There can always be a more comprehensive, more compatible procedure or a provision. But that cannot be a ground for entertaining a challenge to a subordinate legislation. So, this is my first limb of submission, that what is the scope of challenge to a subordinate legislation. Second, third, and sixth facets on which I need to address your lordship, because on the first, fourth, and fifth no arguments have been admittedly advanced. But there is a very well written special bench judgment of the Telangana High Court, where for contractual employees, out of 100 marks, 45 marks or 45% marks was awarded to those who are coming from or who had a contractual service experience. Whereas the other persons, or they call it open market candidates, they were deprived of this 45% marks out of 100. Therefore, obviously, it fell for challenge. Initially, it did not succeed. Then, since it was Andhra Pradesh, therefore, after the state got bifurcated, the second batch of writ petitions filed, where the Telangana said that we are not going to follow Andhra Pradesh. Then a third batch of writ petition filed that why not follow Andhra Pradesh rules. Then the matter was referred to the larger bench. In this scenario, the larger bench of the Telangana High Court was considering, but this is a sort of a digest, this judgment. Your lordship may kindly consider this. This is 2020 SCC Online, Telangana 1073. A longish judgment, but it is considering several judgments of the Supreme Court on several points. May I place, Millard, hurriedly, Millard, a few paragraphs on facts? Please take para 1. On so and so, a series of writ petitions challenging the grant of, comma, or non-grant of weightage marks to contract employees by the state government or by different power utility companies. Now, Millard, skipping the rest, please take, Millard, paragraph number 2. On so and so corporation issued notification for filling up vacancies for the post of sub-engineer, lineman and junior lineman. The notifications prescribed by the selection procedure, that is, out of 100 marks, 45 marks were earmarked for service rendered on contractual basis, thereby leaving only 55 marks for written examination. The grant of maximum of 45 marks as weightage marks depended on the length of service rendered, that is, 2.5 marks would be given for every half year of service as contract worker in the organization. The decision to grant weightage marks was based on a settlement arrived between the managements and such and such. However, the open market candidates challenged the apportionment of 45 marks as weightage marks to the service rendered on contract basis before this court and in a batch of writ petitions. The petitioners therein contended that no such weightage marks could be given to a group of candidates, for it would make the selection totally one-sided. Hence, the grant of weightage marks was arbitrary and discriminatory. However, by the order of so and so, the learned single judge upheld the grant of weightage marks, etc., etc. With the rest of the facts, I've given you, Lordship, brief background of the facts. I will not trouble you, Your Lordship, with those. Now, it was referred to the larger bench because of certain reasons. Now, please take, Millard, paragraph number 20.
Yes.
In the above background, the full bench is required to answer the following issues. Issue number 1, Millard, we are not concerned. Please take issue number 2. As part of the selection process for direct recruitment, whether the employer has the power to apportion marks towards service rendered by a person on temporary basis or not. If yes, whether such power is an enabling power which cannot be claimed as of a right by the employee. To what extent marks for contract service on outsourcing basis can be prescribed out of total marks for the selection. Then, Millard, the cases are categorized. Please take para 21. Under 21, Millard, capital A, Division 1, recruitment in government service. Division B, Division 2 is recruitment to government utility. Under that, category 1, challenge to the constitutional validity of the Rule 31 of the so-and-so rules, which vest power in the governor to, oh no, this is relaxation. I skip over this. Please come to me at category B at the next page. Pertain to challenge the validity of so-and-so issued by so-and-so, by which Rule 9 of so-and-so was relaxed and weightage of marks to contract services was prescribed. Then category 3 is denial of weightage. Then, Millard, these are all categories defined. I will not trouble your Lordship with those. Now, please come to, Millard, paragraph number 55. First, Millard, the issue is answered. Then, Millard, the reasons. Reasons follow the answer. The answer is para 55. The issue is answered as under. Please take Roman 4 under that, or Roman 3 also. The rule is not unguided or unbridled. Enough safeguards have been provided against arbitrary exercise of power of relaxation. 4. Employees working on contract basis are clearly an identifiable group. Thus, they are a class by themselves. We're pausing here for a moment. My submission would be that the persons with teaching experience are a classified or clearly identifiable group. This would be my submission. In yes, in substantive post. And the power to relax so and so, we are not concerned about relaxation. Please skip over 5, then 6. Relaxation of Rule 9B of so and so paves way to compute the contract service for weightage in the process of direct recruitment. That is in the facts of that case. Now, thereafter, Miller, your Lordship may kindly take para 56 onwards. Well, I'll read a few paragraphs, Miller, from here. Before we examine and decide the issues framed herein above, it would be apposite to first delineate the general aspect of selection process, the legal difficulties which arise in the process, and also to deal with the case law on different aspects of selection process. For this discussion would be useful for the final decision about the issues framed and mentioned above. There are certain prerequisites for employment in the state service or in service under the state entities. The eligibility criteria need to be prescribed. Regular recruitment should be made by following the procedure prescribed by the service rules, regulations, bylaws, policy, decisions, circular instructions governing the service. Before commencing the recruitment process, wide publicity indicating the eligibility criteria and procedure for selection need to be given. The selection has to be conducted in a transparent manner. The selection must be in strict compliance of Article 14(16) of the Constitution. Eligibility criteria include educational, professional, technical qualification, experience, age, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both, prescribing minimum pass mark in the written examination and or prescribing minimum pass mark or oral examination, shortlisting of candidates for further selection by holding screening tests, prescribing preference based on higher educational qualification, age, experience, etc. Employer can prescribe tests to assess the skill in a particular discipline, such as typing, shorthand, etc. Thus, it is for the employer to custom tailor the eligibility criteria and or selection procedure as per his requirement. The employer is the best person to assess the qualification required to hold a post and method of selection. Every person who possesses, I can skip over for 59, 60, 61. Please take bullet 62. Recruitment to public employment is a perennial source of litigation. It covers a vast range of issues, from appointing on temporary basis to continuing temporary employment for long years, from not resorting to regular recruitment to reservation to social groups, from eligibility criteria to method of selection to illegalities in the selection process, etc. Broadly, there are 4 aspects to employment in public service. Scope of power of the employer to regularize the services of persons employed on daily wage basis, normal master role, employed on consolidated wages, employed on contract basis, employed on outsourcing basis, etc. For brevity, hereinafter broadly classified as temporary employees. 2, assigning preference. We are here. Assigning preference to a class of person in the selection process for employment. Prescribing a procedure for selection for direct recruitment. Scope of judicial review in matters concerning selection and weightage to temporary service. Then, my lord, please come to para number 76 or 74. But in 74, the heading is assigning preference to a class of persons in the selection process for employment, that is II, and III is prescribing procedure. Employment in the state service, where I skip over my lord 75, not required. Please take 76. 2 fundamental aspects which govern public employment are prescribing eligibility criteria to a post and the transparent procedure of selection. Eligibility criteria include educational qualification, age, experience, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both. The employer may prescribe minimum pass mark in the written examination and or prescribe minimum pass mark in the oral examination. The employer may resort to shortlisting of candidates for further selection. By holding screening tests, the employer may also prescribe preference based on higher education qualification, age, experience. So this is accepted. Weightage on experience amongst others are accepted, etc. Assigning weightage to service rendered on temporary basis and weightage to seniority in acquiring educational qualification also come under the procedure of selection. Employer may prescribe tests to assess the skill in a particular discipline, such as typing, etc. Thus, it is for the employer to custom tailor the eligibility criteria and/or selection procedure as per his or her requirement. The employer is the best person to assess qualification required to hold the post and the method of selection. Therefore, weightage for experience is sanctioned by law. Then we can skip over Miller 2 paragraphs. Or I can read Miller the last sentence of para 78. This is the right, Miller, which Miller an incumbent applicant has. Please take the last sentence in paragraph 78. In fact, the right is of equal opportunity to compete a right of consideration, but certainly not of appointment. Well known, but I need not, Miller, trouble you with all that. Now please take Roman 4, Miller, after para 78. Scope of judicial review in matters concerning selection and weightage. Judicial review of administrative action is the core of our constitutional scheme and the rule of law. It is all pervading and encompasses all aspects of executive actions where rights of individuals are affected. However, scope of judicial review in matters touching recruitment to public employment is in a narrow compass. Judicial review on such aspects is confined to whether any malafide stroke arbitrary decision was taken to prescribe a particular qualification only to favor a particular person, not a class. Or persons, and or such qualification do not at all required to hold the concerned post, but is prescribed in order to eliminate a person or persons. That is why, Miller, I wanted to exclude what was not argued. But the argument is not that this prior teaching experience is not required for the post. And this is what, Miller, the full bench says, that the judicial review is available inter alia for prescribing a qualification which is not required for the post, but is prescribed in order to eliminate a person. No argument has been made that according to me, as I have put it in 2 compartments, that the inexperience gets completely eliminated. And if there are illegalities in the selection process, vitiating the selection, this has not happened as yet. As long as the eligibility criteria and the procedure for selection meets the mandate of Article 14, 16 and 309 of the Constitution, and no illegalities are pointed out in the selection process, the scope of judicial review on the qualification prescribed to a post and the procedure for selection is a limited one. Now, the Supreme Court in para 80, I would like to keep it for my future references, is a digest of the Supreme Court judgments. From the precedent decisions of the Honorable Supreme Court on the scope of judicial review in matters of prescribing eligibility criteria, selection procedure, and the right of a candidate seeking public employment, the following principles can be carried out. Article 14 and 16 or 16 of the Constitution neither exclude the laying down of selective tests nor preclude the government from laying down qualification for the post in question. Such qualifications need not be only technical, but they can also be general qualification relating to the suitability of the candidates for the public service as such. State of Mysore, so suitability of the candidate for the service. I consider an experienced teacher to be more suitable than that of a inexperienced one. Then 2, the court should not usurp the function of determining the appropriate method of selection. So much argument has been made. When should the marks be given for prior teaching experience? At which stage? 2K and 2L. That is why this is important. Court should not usurp the function of determining the appropriate method of selection and the relative weight to be attached to the various tests, even in the case of proven or obvious oblique motive. What would be amounting, that would be amounting to rewriting the rules. The court do not undertake such an exercise. Leeladhar so and so. Matters relating to creation and abolition of post, formation and restructuring of cadres, prescribing the source, mode of recruitment and qualification, prescribing additional and desirable qualification, including grant of preference, criteria of selection fall within the exclusive domain of the employer. The court has no role either in determining the methodology of recruitment or in laying down the criteria of selection. It is the employer who is best suited to decide the requirements that a candidate must possess according to the needs of the employer and the nature of the work. In the garb of judicial review, a court cannot sit in the chair of the appointing authority and decide what is best for the employer. Moreover, the court cannot sit in appeal over the judgment of the employer and ordain that a particular post be filled up in a particular manner. This is what the petitioners have invited the court to undertake. That the court must direct at what stage should the prior experience marks be awarded, or inviting the court to lay down the manner in which it should be done. The court cannot lay down the conditions of eligibility if the language of the advertisement and the rules are clear. The court cannot sit in judgment over the same. In such matters, the power of judicial review can be exercised only if it is shown that the action of the employer is contrary to any constitutional or statutory provision, or is patently arbitrary, or is vitiated due to malafide. It is also not open to the court to make comparative evaluation of the merit of the candidates. That stage has not come. Court cannot suggest the manner in which the employer should structure or restructure the cadre. We are not concerned about that. Next, 4. Since the administrative authorities have experience in administration, the court must respect this. Thus, the court should not interfere readily with administrative decisions. The court should not ordinarily interfere with policy decisions unless there is a clear violation of some constitutional or statutory provision or the statute. There should be judicial restraint in administrative decisions. An enabling provision postulates a discretion which may or may not be exercised. The court cannot find fault in exercising an enabling power in a particular manner. Where the executive action of the state is challenged, the court will tread with caution and not overstep its limit. The interference by the court is warranted only when there are oblique motives or there is miscarriage of justice. The recruitment notification merely amounts to an invitation to the qualified candidates to apply for recruitment. On their selection, they do not acquire indefeasible right to the post, even if all the vacancies notified are not filled up. In service jurisprudence, constitutional court should balance the equality principle with the principle of classification. Dependent on the nexus for making the classification, this aspect is best left to the wisdom of the administrative authorities. Pausing here for a moment, as I have initially submitted 2 or 3 minutes, I have submitted sometimes back, that this is not a pure service matter simpliciter. My lord, in the context of deciding the validity of the rules, has to take into consideration, I won't say has to, needs to take into consideration what is the purpose. The purpose inter alia is to also provide for better education for whom these persons would be, or the intending candidates would be selected. Therefore, that has to be kept into mind. That is it a simple comparison between 5 candidates who have offered their candidature, or is it a consideration amongst 5 candidates who can serve the best or who can provide better quality service for those for whom they are intended to be appointed?
The nexus to be.
Yes, this is the nexus. Therefore, the nexus for making the classification is also very important. Apart from Miller classifying between group A and group B, the nexus is that according to the legislature, persons with better qualification or persons in group A can serve better, persons in group A can provide quality service or education, whatever. Therefore, this is the nexus. Apart from whether weightage preference can be granted or not, the underlying important aspect of the matter is the nexus that these persons or persons with this qualification can serve better or provide better services. Because now we need to also keep in mind that Article 21A has come. Then, Millard, I was in 8. 9. In the mode of selection, if the mode of selection is not prescribed by the rules, and there is no other impediment in law, it is permissible for the competent authority to lay down the norms for selection, such as holding test, minimum benchmark, and written test, as well as viva voce. Paragraph so and so. 10. If classification is otherwise legal, valid, and reasonable, it is not prohibited by Article 14. Because so much of the arguments were made on 14 and 16. I say, Millard, this classification is otherwise valid, has a nexus, weightage is permitted in law, preference is permitted in law, and therefore, Millard, the legislation or the subordinate legislation cannot be faulted. Then, Millard, para 81. Para 81, Millard, is the conspectus of whatever was discussed above. From the above precedential case law on all the 4 aspects, it is thus safe to conclude that we are not concerned about A, please take B. In the process of direct recruitment, it is open to the employer to permit temporary employees and not governed by the directions in para 53 of Uma Devi to compete in regular recruitment by relaxing age regulation and by assigning weightage to such service. Then 3, C, it is for the employer to prescribe procedure of selection for direct recruitment to public employment. While D, while prescribing procedure for selection, it is permissible for the employer to apportion marks for temporary service, seniority, so and so. This E, the scope of judicial review in matters of prescribing qualification, procedure of selection, and method of selection is very limited. The writ court cannot act as a court of appeal and cannot determine what qualifications can be prescribed to hold a post. It cannot prescribe the procedures of selection to make regular recruitment. Only when there is a patent illegality in the selection process would the writ court interfere. But we are not, I mean, the challenge is not to the selection procedure or process. The challenge is, number 1, prescription of prior teaching experience, and when should it be given?
No, the other challenge is whether the prior teaching experience marks can be allotted only to the state government teachers. There are central government teachers, there are private school
Right.
teachers, aided, non-aided, lots.
But
The classification.
that classification, Supreme Court has upheld that you can discriminate.
We'll come to that later
Yes,
on.
yes. Which is called, as per the Supreme Court's words, valid discrimination. But here, Miller, the Supreme Court, Miller, distinguishes between an invalid discrimination and a valid discrimination. I'll come to those. There's a Rajasthan
Judgment has been placed.
yes.
All right, we'll see that.
Then Millard, paragraph number 82, guided by the above principles, so and so. Then I need not trouble your lordship with the middle paragraph. Now please come to para 99. This is a classic case where below 10 marks extra for a particular college. Kindly see. In Sanjay so and so, challenge was made to clause 3 of chapter so and so. Selection was based on written examination.
Hmm.
In the process of determination of merit for selection to post-graduation courses, 10 marks were assigned to students who had graduated from Rohtak Medical College. Therefore, one particular college gets precedence. It was urged that due to assignment often additional marks, the graduates of Rohtak Medical College were pushed up in the merit list. Though this decision concerns admission to postgraduate medical courses, but the basis of challenge is the same as urged in the present set of writ petitions, namely challenge to the grant of weightage mark. However, the apex court repelled the contention of discrimination and of offending Article 14 of the Constitution of India, para such and such. So even in a case where out of 10,000 colleges, students of one particular college gets an advantage, will not upheld. Then please take me to the next one, that is para 100. Consistently, the Honorable Supreme Court has upheld the power, but if your lordship requires me, I can place these judgments, but
No, it's not
yes.
required.
That will make it very long. Consistently, the Honorable Supreme Court has upheld the power of the employer to assign weightage to temporary service rendered by a person and to grant age relaxation while making regular recruitment. Then please come to Millard, paragraph 113. Conclusions on this issue, 113. But please take the last 3 lines of that page. If employer requires. If employer requires a cook, he may prescribe cooking experience more than educational qualification. For a particular post, the employer may give more weightage to experience than to higher qualification, the higher educational qualification. For certain posts, say class 4 posts, employer may prohibit persons with higher qualification. Thus, depending on the requirement of a job, appropriate qualification eligibility criteria may be prescribed. It is the prerogative of the employer. The judicial review cannot be stretched to oversee what qualification, eligibility criteria, and the mode of selection should be prescribed by the employer. In the present cases, admittedly, there is a large pool of employees having basic qualification who have undergone processes of selection, have rendered considerable service, and have gained experience in the core aspects of the job for which recruitment process is being taken up. Experience gained by them is certainly useful for the employer. The employer may thus prefer a person with experience over a raw person. Therefore, preferring a person with experience on the same job neither amounts to bias nor to arbitrary exercise of power. It is a classification based on intelligible criteria, that is experience on the same job versus inexperience. So it's a choice between experience and inexperience. Que the purpose, the ultimate purpose. But here, of course, the Supreme Court, the Telangana High Court was not considering the purpose or the other aspect. Then please take me, Lord, weightage, 118. Thus, grant of weightage marks is legally permissible. Hence, the arguments raised by the learned counsel against the grant of weightage marks are clearly untenable, hence unacceptable. Issue number 3. Whether such power is an enabling power which cannot be sought as a right. Ancillary to these issues are 2 more questions. A, whether employer, the state or its instrumentality is under obligation to extend the scheme of weightage to temporary service rendered outside its employment or not, and B, whether not extending the benefit of weightage marks to those outside the employment of the power utility companies would offend Article 14 and 16 of the Constitution. But then para 123(1), Millard, are examples of selective weightage, Millard. Yeah. But kindly permit me to come back on the next day, Millard.
Could you finish up with this judgment and
Well, I have to read, Millard,
more paragraphs?
at least 10 to 12 other more paragraphs. That's why I said, well, this is a digest. I'll keep it, Millard, for my future references.
All right. Ready? The learned AG commences argument, but does not conclude the same. When would you like to come back?
But I can come back on Monday or next Tuesday also. Millard. Today we are on
10th.
Tuesday.
10th, next Tuesday.
Very good.
10 তারিখ।
Ninth.
কি হয়েছে? ক্যান টুটা নেই?
Well, in this matter, I was added later on, and Lordships granted me to use an opposition also. So,
You want to file it?
Yes, it is identical. It is same thing, but still.
The opposition দিচ্ছে একটু দেখে নি। Please file it.
Weekend একবার আসিস।
How many? How many? One means in volumes.
There are volumes of the SLPs and others. There's nothing new, and these are already.
Why add up documents which are not relevant or
These-
copies are there?
Because this is not going to.
And
India.
affidavit in opposition filed by, check up by who? And in 4 volumes.
তো এটা নিয়ে
Please write that.
No,
No, he'll be getting all copies to be circulated.
You are the main person.
Certainly copy will be given.
Several affidavit filed by some of the copy I get
You write letters
As
so
far
that the
as I am
copies can be
concerned,
given.
There is no difficulty.
রাহুল কি
in
আবার
all copies.
Please write to the advocates for furnishing copies.
It is very much difficult to follow
কদিন
the
হয়
who
on
process of which matter he get that.
You have the affidavit, the application for addition of parties. From there you can trade.
Everyone not get that.
Application for addition of party also not given.
Some of the person I will get it.
Mala, this is a.
Any applicant who has not served copy, please serve copy upon the writ petitioner.
এবং affidavit গুলো follow করো যেখানে copy দাও। Copy দাও।
Did you serve the application? Not the opposition, the application you served. The court added parties even though applications were not served with the direction to serve. And thereafter, these are not served. See, this is a submission that is being made.
Copy দিয়েছো দেখাও।
Item number 21 can
এটা দিয়েছো affidavit দিয়েছো?
না আমাদের কপি
প্রদীপ,
দিয়েছো?
সার্ভিস
Can 5
কাকে?
বলছে allow হয়ে গেছে, but it is still
Juniors.
if the opposition,
Oh, that's a different matter. then.
item 22, opposition,
কাকে দিয়েছো?
21,
বুঝো?
21, opposition filed by the which respondent? Clash applicant in can 5. It will be open for the petitioner to file reply if required.
Yes, yes, my lord.
Otherwise, so many applications are there.
After filing all this, my lord, I will
And
use the
seven-
consolidated reply, my lord.
seven
Otherwise, my lord, it
letters-
is very difficult to follow each and everyone's, my lord, evidence.
Anything else?
But we are yet to receive the copy of amended cost title after addition of parties.
Resolution to.
The applicants are being added on daily basis. So we still do not have an amended cost title.
In process.
Uday Shankar Chattopadhyay, Suman Shankar Chattopadhyay, or Pranay Basak over here? Any of them? No. Petitioner in Bhim Sarkar is you.
Fine, fine.
Did these advocates file any application? Can 6?
And 6 years. The last occasion, my lord, remember that
হ্যাঁ withdraw করে
last occasion, Mr. Uday Shankar Chatterjee, my lord, make submission thereafter, probably memory.
Disallow the cancel.
Disallow. And my lord, I believe they preferred an
appeal.
আমাদের কাছে copy
আচ্ছা Chattopadhyay, so that at 2 o'clock, right? This was mentioned. I do not know what is the reason.
mention.
It has been mentioned.
Correction.
এগুলো একটু ঠিক করে দিতে হবে। এটাকে রাখুন, 2টোর সময় আসবে তখন কথা বলে নেব। Item 19 is being heard, and with 2021 opposition file 22, 23, 24.
Up to 24.
Opposition
24.
filed in 19 also,
Yes.
and that opposition is for can number 3 added respondents.
লিখে নেবেন কিন্তু। All right. So we'll start from 25. তাই তো?